Welcome to another episode of Should You Take That Case with your host, Lisa Wade, your friendly neighborhood legal nurse consultant, owner of Wade Nurse Consultants, and creator of our private LinkedIn community, the Attorney Medical Record Resource Group. That is where we get all of our stellar attorney guests. The goal of our show is to be a resource for legal professionals who pursue medical cases by sharing their experience and insights as defense or as plaintiff attorneys. You can catch prior episodes at www.wadenurseconsultants.com/blog, on LinkedIn and on Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Should You Take That Case, Lisa Wade.
Hello. Happy Monday, everyone. Or Happy Medical Record Monday. That's what we call it. And here's another episode today of Should You Take That Case? And I am your host, yes, Lisa Wade, your friendly neighborhood legal nurse consultant, medical record expert, and owner of Wade Nurse Consultants. Visit us at wadenurseconsultants.com and think of us when you have those tons and tons of medical records you need translated into normal human language, easily understood by judges and juries. Like I said, wadenurseconsultants.com, that's where you'll find us. But I am also the creator of our wonderfully private LinkedIn could been out. We're going to scoot on over to
Texas, Oklahoma, Nevada, Washington, like I said, Illinois, Missouri. I've got a couple cases in Alabama. It's kind of all over the map. But yeah, the home state is Missouri and Illinois.
Oh, well, excellent. I'm glad you're here. And I want to learn a little bit more about you. We're going to talk about medical records and how they pop up during your cases and the impact that they have. But first, tell us more about you, how you got into this area of practice, how you got to be an attorney. Go as far back as the crib if you like.
Well, I mean, in terms of starting practicing law, the initial push was realizing that political science as an undergrad degree is totally worthless. And so, I was like, well, what can I do with that? Well, I liked the classes that related to the judicial branch of government and stuff like that. So about in my junior years when I thought, well, being a lawyer, that kind of sounds like something I'd want to do. And that was definitely the right call. I really enjoy the strategy and the back and forth and all that stuff when it comes to trial work. So I came down to St. Louis. I grew up in Minneapolis. I came down to St. Louis sort of on a whim, really. And I met my wife my first year of law school. She's also a practicing attorney. Her name's Liz Ramsey. She does criminal and wrongful convictions and stuff like that. We got married right after law school. We had our first kid pretty quick after that. So what happened was, I get out of law school and I just kind of needed to get the first job I could get, because I had, $1,000 credit card bill, about $100 in the bank, and so I started working at a firm called Brown and James, it's kind of like a regional insurance defense firm. So I did kind of all the things that you talked about in that bio section, a lot of personal injury cases, but then the consumer class actions and some insurance fraud investigations too that related to chiropractors and pain management clinics and stuff like that. And so, those are super medical records heavy, and we can get into some of that too. But I've walked away from that area of my practice. But that's something to keep in mind for anybody that's dealing with medical records. Insurance companies will look at it on the claim level, but also on the higher, what's the forest look like to see, are there patterns in these records? If you're a provider that's touching a lot of injury claims that don't make sense over a lot of people, not everybody can have the same diagnosis. Not everybody can have the same objective findings. Not everybody's going to have 9 out of 10 pain. And if you start seeing those types of things on a wider scale, that's when they're going to be looking at you and deciding whether or not more should be done. So that was a piece of what I did previously when I was on the defense side.
Oh, well, now tell us a little bit. You've made a shift, you made a pivot. I'm just trying to find out what factors go into you deciding now if you should take some of these cases that come your way, or if they are cases you should refer out. How do you make those decisions?
Yeah, that's a good question. I think so. I handle different types of cases. There's the injury cases where, if somebody was in an accident, they're saying they're hurt. Okay. It's a little more obvious if it's like musculoskeletal, because, just a soft tissue injury alone is a compensable injury. Whereas some of the mass tort stuff that we do is you're really looking at, do they have a particular diagnosis, right? So like asbestos exposure, you're going to be looking for lung cancer with a certain type of underlying disease. That'll be like a bilateral asbestosis or pleural plaques or something along those lines, or you're a mesothelioma, right? So the medical records can serve as a gatekeeper for certain types of cases like that, where if you don't have the right diagnosis, you don't have a case. Whereas with the personal injury cases that are more musculoskeletal, a lot of times you're looking more at who's the client, how well do I think they'll present, is it believable that they have the injuries that they're claiming, and then if they go beyond that to having to undergo an MRI and having something more objectively saying, yeah, there's a bulging disc here or something like that. Okay, well then that's making it a better case. But so I think it depends on the type of case. It can be a gatekeeper, yes or no. Otherwise, it's a conversation with the client up front about the reasonable expectations for the value of the file.
So it sounds like those mass cases, people have to fit into certain slots
exactly.
of diagnosis and problems, but those one-on-one individual personal injury cases is more individualized.
Yeah, absolutely. And I think another mass tort that's kind of, coming out here more recently is, I think it's a hair straightener or something like that. I don't work on these cases, but I know it's something that people would put in their hair. Okay. Straightener.
Relaxers.
Relaxer. Boom. You got it. In those hair relaxer cases, I think that there's certain types of diagnoses that are, man, I'm speaking way out of school because I don't handle these cases. I just kind of see this stuff. But I believe that it's like a urinary cancer is the one that's really sort of the science is a little stronger on causation, whereas there's some other diseases and diagnoses where it's like, okay, maybe, but it's not as matured. So, and that's what's kind of interesting about the mass tort cases is you got to get that medical and see the diagnosis to check that box to know if you even have a case to begin with. Whereas, yeah, those injury cases, it's a little more fluffy in terms of how you're evaluating it. If that makes any sense.
I got you. Now, so you're deciding, or you've decided that you're taking this particular case, and those medical records are rolling in. Is there a particular process you have for going through those records? A routine, as it were.
Yeah, so it's really nice with our firm because we have staff that's dedicated to doing that check the box aspect of the medical. We that's one of the first things we're doing in the intake process is we let our clients know, okay, we're going to bring your case in. First thing we got to do is confirm the medical. And so, you'll get an email in the firm on one of your files, diagnosis confirmed, and it's time to proceed on that file. So that's makes it easy on my end because somebody else handles that. But on like an injury file, I want to get the story right. So I want to look at my client, what my client's saying about their illness or their diagnosis or their injury or whatever. So for me, let me give you an example. I've got a case right now where my client was rear-ended by somebody, and the really major injury was actually to his right toe, his big toe, because it was on the brake at the time that he was rear-ended, and so it got pretty hurt. he actually he couldn't go to work for several months. He worked at Trader Joe's. He had to be pretty active on his feet, lifting things. And so that was really the bigger thing, but he didn't really make any big deal out of it until later on. And I know, working on the defense side, that gaps in treatment are going to result in the insurance company saying, oh, there's, that this maybe isn't related, or, he didn't get treatment until later on. So one of the first things I wanted to confirm was, when did he start complaining about this? Because he also went to the chiropractor for a neck injury pretty quickly after the accident that wasn't as major, right? Well, he complained about that stuff to the chiropractor right away. That stuff, I mean his toe injury. And so even though he's not getting treatment for it and he's toughened through it at work, it's still something that's been noted in a medical record right away. So that was something that made me think, okay, that is better for the case. He's complaining about it. And so in my demand to the insurance company, I note that, I quote the record. I'm like, he's complaining about this toe from the get-go. So the medical records oftentimes tell the story, your client's story, in a more objective, documented fashion, where this is what the client is telling their medical professional that's helping them, what they're experiencing. And so I always like to look, and it works on the defense side too. The subjective section of the records tell the story from the client's perspective, supposedly, as reported by the provider. On the defense side, you can find all sorts of good admissions then in those subjective sections. And I've even had cases where it's very clear that the medical professionals don't exactly like the plaintiff, and they will quote the person as saying like stupid or awful things. And so you definitely want to look at what the plaintiff is saying, because that's going to lead you to questions about party admissions. And that's an important piece of things, because that's an exception to the hearsay rule. And so you want to be able to put that in front of the plaintiff during their deposition or going into trial to get admissions on what things were being said about their condition. So the story is huge. And then obviously anything that either proves or on the defense side disproves objective injury is important. So a lot of times that's imaging. And I can give you another example. There's a case that I had where it was very important, the MRIs of somebody's shoulder, because this person was complaining of first a right shoulder rotator cuff tear. Okay. What happened was the other driver backed into this woman in a parking lot, and she claimed that her right shoulder fell on top of the car. It was a slow, so she wasn't claiming to be totally, have a ton of fractures or anything, but that falling on that car resulted in a tear of the right rotator cuff. Okay, and we weren't disputing that the right rotator cuff was caused by the accident, but she then goes through treatment. She goes through physical therapy, and she's making her demand. And she claims that after she was treated for the right shoulder, she developed a left shoulder rotator cuff tear due to overuse of the left shoulder while the right shoulder healed. Okay, well, we needed to confirm this. Now, I represented the underinsured motorist carrier, so really, I didn't even represent the driver, okay? I represented her insurance company. But what we wanted to figure out then was causation, right? So, of course, we wanted to know what kind of imaging existed directly after you finished treatment for the right shoulder and you could start using it again. Well, we got our hands on an MRI that showed, the statement in the MRI was there is no tearing of the left rotator cuff, which she was claiming was an add-on to the right. She also went to the same orthopedist that did the surgery on the right, and he looked at the MRI and said the same thing. What she didn't provide to us that we only got later in discovery was, documents from her primary care physician that she's not complaining about the left shoulder. So there were a lot of issues with that case and causation. And it was really, from my vantage point, it seemed to be attempting to stretch the UIM claim to get more. The result of that case was it got dismissed because she refused to cooperate with us pre-suit. There's a cooperation clause in every insurance policy, and she's the insured. It's an obligation of hers. So the stonewalling pre-suit ended up dooming her claim to begin with. I made some bad law for the plaintiffs now that I'm on the plaintiff side, but that was the result of that case. But yeah, so the medical records are huge in terms of, if you have a theory of how you got an injury, but the imaging just doesn't jive with that, then you're going to have a problem. Because in the piece that I left out of that case was then fast forward another year, she got another MRI of the left shoulder that did show a rotator cuff tear. So something had to have happened, or it was degenerative, right? That, at least that was our perspective on it. And so those medical records and that imaging in particular is huge when it comes to causation.
Yeah, I get you. It sounds like you're trying to match up what your client is saying, or the whoever the injured party is saying, matching it with objective data that's found in the records. And sometimes it takes time to get, to find all of those spots inside of a record. But yeah, knowing the story and finding all the data in the records, yes, I understand that. It's an important part of your case.
And in that case, it was a big deal too, because you need to know what records exist, and you need to compare it to what records your opposing side's expert is relying on. Because if they're ignoring certain important stuff, you need to be able to point that out to the jury. And in that case, their experts, they had an orthopedic expert that they hired pre-suit to write an opinion. And in that opinion, he lists out what imaging he had. He did not have that MRI that showed no rotator cuff tear in the left shoulder when he wrote that opinion. And so, that really hurt his credibility in the case. He had to scramble to come up with a theory on, well, you see this tiny little piece here on that MRI? Well, we can't see a tear, I admit that, but that suggests the possibility of a tear. And it was just, it just didn't work out for them, and so you want to, anytime you have a medical case, and there's gonna be experts involved, usually if there's some issue with medical, you got to compare what exists with what the experts are relying on, because they may try to ignore that inconvenient fact, and you got to hammer them when they do.
All right. Well, it sounds like you, sometimes you are reviewing these records yourself, and sometimes you have a crew that reviews them. What, if anything do you find frustrating, or do you have any pet peeves about going through those records, what they're saying, how they're organized? What annoys you about them?
Oh gosh, I think the thing that annoys me the most is just the quantity, especially from like a hospital. There's just so much stuff in there that, at least for the lawyers, and maybe it's necessary, but at least from my vantage point, it's just not really all that important. And so you get 60 pages of stuff that, I could condense down into a page the stuff that I actually use for the case. That's probably hyperbole, but you get what I'm saying. There's just a lot of fluff in those electronic medical records. That's just what makes it difficult, especially if you're trying to have somebody else help you put together the chronology, because then getting them to understand what pieces of information actually matter and you care about is tough. It almost takes you less time just to go through the record yourself, because you know what you're looking for. So yeah,
I hear you. So you have given a lot of good information, a lot of experiences that you've had yourself. And what advice, that you haven't shared so far, what advice can you give any newbie or veteran attorneys regarding these types of cases?
Man, it's a tough question, because medical records become important in so many different types of cases. So in a med mal case, which I don't handle med mal, what you're digging into is going to be different from a personal injury case where what you're looking for, just what you're looking for is different, right? In a med mal case, was there a breach in the standard of care? Whereas in a PI case, you're just trying to figure out causation and damages and that sort of thing. So, I mean, I guess that's a long-winded way of me trying to avoid answering the question. But, I mean, in terms of advice I think I could speak to the new lawyers on this, that you really should, before you dive into medical records in a case, talk to a paralegal or senior associate or somebody who has done this before and figure out what's the important stuff. Because otherwise you're going to feel a little overwhelmed and you're going to spin your wheels. There's only so many things in those medical records that are important for your case. And that doesn't mean you should ignore a bunch of stuff in the medical records and go too fast, but you should know what the really important stuff is so that you get that down. Because there's nothing worse than getting to the end of a case and realizing there is critical medical information that I didn't utilize, or there's a clear clue. Oh, and this is another piece. The medical records will give you clues as to the existence of other medical records you don't have. So they'll mention referrals to other doctors. They'll mention orders to get imaging. They'll mention the medical history of somebody. And, this person got a knee surgery 10 years ago. You want to mine the records you've got for clues to the existence of other records, especially on the defense side, because otherwise you're going to miss that stuff. And you've got no real, you're going on a fishing expedition is what it looks like on the defense side if you want to go 20 years into the past, right? But if something in the records in the case shows 20 years in the past as relevant, a prior surgery or something like that, well, now you've got a basis to go to the court and say, I have good reason to go 20 years in the past. Look at what this says in this record. And so you're going to be able to build your case more if you pay attention to what clues are the records giving me about the existence of other stuff. So it's part investigation, it's part evaluation, because those records on an injury case are going to help determine the damages and causation, for sure.
Oh, good. Well, it sounds like following medical records is like following a trail of breadcrumbs.
Heck yeah. Yeah.
Well, thank you, Ben, for coming. It's you're sharing all of your knowledge, all your expertise. It is definitely appreciated. And now it may be time for a little Q&A. Is that something that you're ready for?
We'll find out, right?
Okay. All right. Well, now everybody, you have time to get your questions together for Ben if you're visiting us live. But even if you're catching the replay, leave your questions in there when you have them, and hopefully Ben will get to them. Now, while we're waiting for you all to get your questions together, now it's time for what I call a small sponsor break. And let me tell you a little bit about Wade Nurse Consultants and what we do here, and then we'll get right back to Ben. Now, everyone is not always completely clear about what legal nurse consultants do, but I'll make it clear for you today. At Wade Nurse Consultants, it's all about review, research, and roadmaps. When we review medical records, we summarize and translate that info into human language easily understood by judges and juries. When we research, we complete medical literature searches regarding topics attorneys may not be familiar with, or we are researching and locating experts to help them support their cases. And when we create roadmaps, we create life care plans, which are roadmaps for injured clients detailing their future medical needs over their lifetime, including estimated costs of that care. To recap, legal nurse consultants at Wade Nurse Consultants. For us, it's all about review, research, and roadmaps. And now let's schedule a free 15-minute medical case strategy call by clicking the calendar link you'll find in the description box of this YouTube channel, and let's have a chat. But now let's get back to Ben. All right, Ben, let me take a peek. Are there any questions ready for you yet? No, but that happens sometimes, and I've got a plan for that. What I can do is I can, and I probably have already, put your contact number or a contact information inside the description box of this YouTube channel for people who are catching us on the replay and they have questions for you. They can reach out. Does that sound like a good plan?
Sounds good.
All right. And I have one question for you, Ben. Will you come back and do this again?
Yeah, why not?
All right.
That's fine.
That's good. It looks like we are winding down. We don't have any questions. Let me check. Nope, no questions yet. But let me just remind everybody to click over to this YouTube channel, subscribe, turn on that notification bell so you will be ready to see us and be with us on our next show. And if you have any questions that I can answer about legal nurse consulting, let me just give you there it is. That's Lisa at WadeNurseConsultants.com. Reach out if you have legal nurse consulting questions. But just join us next time for a brand new episode of Should You Take That Case? And we'll see you next time. Thanks for coming, Ben.
Hey, thanks a lot.
Thanks for watching and listening to another episode of Should You Take That Case with your host, Lisa Wade, your friendly neighborhood legal nurse consultant, owner of Wade Nurse Consultants, and creator of our private LinkedIn community, the Attorney Medical Record Resource Group. That is where we get all of our stellar attorney guests. The goal of our show is to be a resource for legal professionals who pursue medical cases by sharing their experiences and insights as defense or as plaintiff attorneys. You can catch prior episodes at www.wadenursconsultants.com/blog, on LinkedIn, and on Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for subscribing to our YouTube channel and sharing this show with others.